Good evening, everyone. I'm just going to do a slow introduction, just while we get ourselves ready. Just a few matters of housekeeping. The chat function is disabled. We have the Q&A function. Before I introduce how we're going to deal with the topic and introduce the panelists, what we're planning to do is we've got slides. There is a handout which will be available to all attendees who've signed up. So the handout that you can see in the slides that you'll be shown will be emailed to you after the event. The event is being recorded. What we'd like to invite you to do at the end of the event, or even as we go along as things occur to you, if you have any comments or questions, do put them in the Q&A section, and I will be making a note of them, and we'll try and fit in as many questions at the end. Because this is an interesting and complex area and developing area of law with schedules of fact findings, we'd also like to invite the audience, who I've seen as a very experienced audience, to share their practices and experience, and also questions about how they, or comments on how they do things with schedules of Scott schedules involving domestic abuse cases. Right, I'm going to introduce the panelists now. First of all, we're hoping to hear from Arlene Small, who is a very experienced barrister and who specialises in family finance and children work. She deals with children proceedings, adoption, Schedule 1 of the Children Act, care proceedings, domestic abuse, divorce, financial remedies, and cohabitation cases. Arlene Small represented the father in the case of Re-H, together with Denise Gilling QC and Melissa Elsworth. Arlene will be speaking about the need and scope of a fact-finding hearing, and also, if a fact-finding is necessary, how a fact-finding should be conducted, with focus on allegations of coercive and controlling behaviour. After Arlene, we're going to hear from Denise Gilling QC, who will be speaking about the challenges of Scott schedules. Denise Gilling QC, known to many of you for her astounding technical ability and her keen eye for detail. She's got a wealth of experience dealing with complex cases, both in public law and private law. She deals with cases involving sexual abuse, physical harm, non-accidental injury, cases with an international or cultural dimension, and emotional abuse and chronic neglect cases. She also represents children, both with and without a guardian, and is experienced in separate representation of children. After Denise, we're going to hear from Melissa Elsworth, and Melissa will deal with the use of criminal concepts within family proceedings. Melissa is developing a broad practice dealing with private law children, public law children, family finance, property, surrogacy, international family law, and applications under the Family Law Act 1996, that's domestic abuse cases. Finally, we're going to hear from my colleague in our Leeds office, Claudia Gilham. Claudia Gilham is a very experienced solicitor, and she deals with complex children and finance cases. Recent cases involve financial settlements dealing with a number of jurisdictions. She's regularly dealt with cases involving fact-finding hearings. Claudia is also a trustee of a large domestic, or in fact the largest domestic abuse charity in Yorkshire. Claudia, who is our final panelist, will be speaking on the issues which the Court of Appeal were invited to address but didn't express conclusive views on. Okay, let me just see. Arlene, may I hand over to you? Arlene, I think you need to unmute unless others can hear you.
Right, I've unmuted. I was just saying good evening to everybody, and thank you all for coming out. This is quite nice actually, because I did recognise some of the names on the list who I haven't seen for a long time, and it almost feels like a massive reunion. So it's quite nice to be able to do these sorts of seminars with the wonders of technology. As already been explained to you, I'm one of the team that represented the father in REH, which was one of the linked Court of Appeal cases that we've all just recently had the judgment for. And although these matters are obviously very serious and very difficult and challenging to deal with, it was also a very exciting time to be a practitioner. Just having that experience of hearing from so many experienced advocates in the case, being able to just grapple with these very difficult and challenging issues. There was a sense of camaraderie around the hearings as well, because as most of you will be aware from reading the judgment, particularly as far as the fathers were concerned, we were acting pro bono in circumstances where these fathers would have been unrepresented. Whichever view you take about the outcome, it's commendable that we were able to do that for them. Sometimes not many positive things are said about the legal profession, but certainly I would say that this was one of our more positive opportunities that we had to really promote the work that the legal profession does. So just coming on to what we're all here to discuss, there are slides, and as has already been said, that you will be able to have these afterwards, but just highlighting really what came out of these 4 linked appeals. First of all, you'll see from the screen the issues that the Court of Appeal dealt with. When is a fact-finding necessary? How to determine the scope of a fact-finding hearing, considerations when conducting a fact-finding hearing, suitability of Scott schedules, and whether the family court should use criminal law concepts. Now, the Court of Appeal, understandably, was extremely limited in what it could do, because the mainstay obviously were the 4 appeals. However, what it did do was highlight those issues. If we can just go back to that slide for a moment, please. What it did do is highlight and provide some guidance on these matters, particularly in the issue of when is a fact-finding necessary. There will always be those cases where, whilst one has a great deal of sympathy for the person who comes forward and says that they have been the subject of whether it's coercive controlling behaviour, physical violence, emotional harm, financial abuse, whilst one will have a lot of sympathy for those individuals, the real nub of the case will be whether it's necessary to have a fact-finding to deal with those. And what came out very firmly in the Court of Appeal's guidance was that really at the heart of all of these is the welfare of the children, or welfare of the child, and whether having a fact-finding is going to impact the decisions and case management that the court has to undertake in dealing with matters of the issues concerning the welfare of children. So just in terms of our day-to-day practice, there is an element of having to manage the expectations of those that come to us with those concerns and with those issues, to ensure that at all times we are focusing on, as I say, the paramountcy principle, which is that the welfare of the child comes first. And that's not to say that we leave individuals in these situations without a remedy. There are, of course, applications that can be made under the Family Law Act. I'm talking about injunction applications and, of course, occupation orders and so on for individuals who are in vulnerable or difficult situations where they feel that their health and safety is being put at risk, or more importantly, that their child's health and safety is being put at risk. So in terms of the necessity aspect, the Court of Appeal made it absolutely clear that that is what it was going to be focusing on. In terms of determining the scope of the fact-finding, again, I just want to say a couple of things about that. That there is a huge dilemma for us as a profession, and for those of us that are practitioners working, about how much information should be the foundation of any fact-finding hearing, because sometimes these relationships have gone on for a very long time, sometimes decades, and sometimes the opportunity to, as it were, focus on 1 or 2 allegations, or sometimes judges will say no more than 5 or no more than 6. it's a very, very difficult exercise in terms of trying to analyse which allegations to focus on, how broad they should be, over what period of time, and so on. And there is, again, some guidance in the Court of Appeal decision about that, primarily that we should be looking at course of conduct now, as opposed to individual allegations. I think it's fairly clear now that focusing on individual allegations is really not doing justice to the severity of the situations that are the individuals that we're dealing with find themselves in. So I think we're moving, certainly moving to a much broader approach. There are going to be some obviously ongoing discussions about matters such as Scotch schedules and their suitability, and also the criminal law concepts, which I know I'll say my learned friend Miss Elsworth will be dealing with later, so I won't say too much about that. But if we can now move to the next slide. And I know this is again, I'm not going to read out everything there, but essentially you'll see at the very top interim contact, which is very unfortunate, because when allegations are made, it's normally contact is automatically suspended or immediately suspended unless there's some either well-meaning family member that can assist with supervision, or a contact centre, which is not always ideal with older children. So that is something that which the Court of Appeal did not touch. In terms of the nature of the approach, inquisitorial or adversarial, that was left untouched, and the mandatory self-directions for judges. What the Court of Appeal did do, and you'll see from reading the judgment, is make some very clear comments about some of the comments that were made by the judges, but stayed well clear of, as it were, offering up a standard form of words that judges should use. And from my point of view, I think that's got to be right. Each case has to be treated on its own individual merits. And then there's the application of the practice direction and the use of checklists, which ordinarily should be happening anyway in pre-trial reviews and pre-hearing reviews, where the judge conducts that exercise to make sure that everything is as it should be in terms of case preparation. And one of the things that I think that's missing from here that the Court of Appeal did not deal with, which I again was personally disappointed about, was the issue of funding, particularly for fathers who are unrepresented, and how that's going to be addressed. Or any individual that is facing allegations. It may not necessarily be a father, but any individual who's facing allegations, there does seem to be a lacuna in terms of how they are represented, or they obtain representation. And in fact, the father in Re H, what was unique about his particular case was that he did not have funding for his fact finding, so he was completely unrepresented. So he did not have the benefit of solicitor, he did not have the benefit of counsel. He effectively represented himself at that hearing. Whereas I think in all the other appeals, at the fact findings, both parties were represented. So if we can go to the next slide, please. Is practice direction 12J still applicable? A resounding yes. It's fit for purpose, and I would encourage us all as practitioners and individuals working in this area, if we haven't read practice direction 12J from start to finish, it is worth reading. And that might sound odd, but sometimes we focus on certain parts of practice directions that we need for a particular case that we're working on, and perhaps don't read that all the way through. But it's encouraging that this piece of this practice direction is still, as it's described there, fit for purpose, and we can rely upon that. The issue is ensuring that it is properly implemented, and helpfully that's bolded at the bottom there in terms of the implementation of practice direction 12J. And it's really important that when we're approaching these cases, we take the time to ensure that everything that should be applied as far as this practice direction is concerned is applied, and that there aren't any gaps which could lead to either an injustice to an injustice against either the person bringing the allegations or the person who is who has had the allegations made against them. So that's very important. When is a fact finding necessary? there's an argument for saying that once an allegation is made, that there should be a fact finding, but we know that the court simply does not have the resources to deal with that, and that ultimately that's not always in the best interest of children. The relevant paragraphs that have been highlighted there make it clear not every case requires a fact-finding hearing, even where domestic abuse is alleged, and that this needs to be addressed at a very early stage. And I know that there has been some question mark about when it should be raised, when it should be considered fully by the court, particularly in circumstances now where what appears to be happening, particularly in the family proceedings courts, is that when the Fahudra hearing takes place, you don't have a bench. You will have a legal advisor who is, although tasked with case management decisions, can't actually make a decision about whether a fact finding should be is necessary or not. And so in some ways, an early opportunity is sometimes wasted. And one thing that we may want to think about as practitioners and people working individuals working in this area is whether an early approach to the court needs to be made once it's been identified to us by our client that this is a concern or this is an issue that's going to be raised, whether there should be an early approach to the court to say this actually needs to be listed before a bench at that level. I understand the county court, higher court will be different, but at the family proceedings court level, that this case needs to be listed before a bench because there are issues that will need to be determined, namely whether a fact finding is going to be necessary or not. And that can sometimes avoid a lot of frustration where, as I say, one turns up, there's a legal advisor and he or she will say, I can make these level of directions, but I cannot make a decision about whether there needs to be a fact finding or not. And then there's another 3 or 4 week delay, sometimes 6 week delay, whilst a bench is convened to look at an issue which was raised at the outset of the proceedings. In terms of when it's actually necessary, you'll see again, we defer back to Practice Direction 12J to provide a factual basis for any report or other assessment. And that's quite key. If these issues are not dealt with at an early stage, what you then find is that later on down the line in the case, they as it were rise like spectres from the dead to come back and haunt you because they weren't addressed very, very early on. That the factual basis upon which the court makes decisions is extremely important, and it's got to be accurate. And you'll see, in fact, in one of the cases that went before the Court of Appeal, that this was one of the main reasons why, and I'll just we'll come on to that a bit later, but that essentially it was decided by the Court of Appeal that it was absolutely essential that a fact-finding hearing take place to have an accurate basis upon which the court could make welfare decisions about the child in that case. There's also the issue of the President's guidance, which I hope we've all read. This is in some ways guidance, again, more to do with those that are having to manage the expectations of those that come to us with these allegations. And that's what, again, whether it's somebody who's brought the allegations or someone who's being who has, it's been said that they have behaved in a particular way that requires a fact-finding hearing to take place, that the court will have to case manage that, will have to limit the issues to only those which it's necessary to determine to dispose of the case. So the court really has one eye down the road of the final hearing, although understandably it's going to be quite difficult to explain this to a client. We as lawyers and practitioners understand the legality of the situation, and this has to be dealt with very, very sensitively, particularly looking at paragraph 46 there. An oral hearing will encompass only that which is necessary to determine the application before the court. It's not going to be an opportunity, unfortunately, to revisit everything that has gone wrong in the relationship. There will need to be a much more narrower scope. If you could just go to the slide about CAFCAS, this particular point, and I know there are CAFCAS practitioners on here, this is a very difficult one, in as much as at the moment the system allows for the safeguarding letter. But what tends to happen with the safeguarding letter is you get a list of what one party says the other person has done. So you get a list of allegations, but doesn't appear to be the opportunity for any analysis of or risk assessment of those allegations. Then what seems to follow after that is that when you get to court for the Fahudra, there is a different CAFCA officer. So not the person who has taken the telephone call, spoken to the individuals concerned and noted the allegations. There's a different CAFCA officer. But again, they are limited only to what they hear in the hearing and what's written in the letter. And so there does seem to be, again, yet another missed opportunity for the court to really take in hand these issues about the use of a fact-finding hearing, the nature of allegations, whether these are allegations which should be the result of a fact-finding trial, or whether they are simply part of the background of a relationship and just there for context, whether they're going to impact the court's decision as to whether a parent who it is alleged has behaved in a way that is abusive should see their child. So I would certainly endorse a move towards giving CAFCA greater involvement in that process beyond just submitting a letter and beyond simply sitting in the hearing and hearing what the allegations are without necessarily having any opportunity to make any sort of assessment, and no directions are made for any assessment by CAFCA at that stage. Normally that is pushed down the road for the Section 7 report. That's when the as it were the meat of the case is looked at. But I certainly think there's an argument for that happening much earlier on in the case. I think I've already more or less covered this. I certainly don't want to labour that point about the scope of fact finding. Thank you, Melissa. About conduct, how to conduct a fact-finding hearing. Again, there is no one size fits all case. There is no one opportunity if you don't plead an allegation in, for example, the C1A, that thereafter you're forbidden from pleading it forevermore. It really is a question of taking time to sit down, take instructions from your client and ascertaining at that point how much information is going to be required for the judge to be able to, first of all, decide that a fact finding should take place. And then early, as I say, early consideration of things like the questions that are going to be asked, the manner in which the actual hearing room is going to be set out, although perhaps that's less important, well, not less important, but less prominent now, given that most of our hearings are being conducted remotely, that the implications for your client giving evidence, the implications for the I don't want to say the father, because it in some instances, and certainly in one of the appeals, it was that the mother was also found to have behaved in a way which was abusive. In the sense that if you're conducting a fact-finding hearing, how is the questioning going to take place? Should it be the judge? What is unusual about all of these cases, in fact, this should have been on the earlier slide, was that the court did not make any specific direction about how these hearings should be conducted. But what's key is that there needs to be early consideration of all of these elements that I've just summarised. This point about the judge overstepping the mark, in the case that we were representing the father in Re-H, the fact-finding hearing, in fact, was conducted almost entirely by the judge. We have the benefit of seeing the original transcript of that hearing, which of course is confidential, but essentially the judge in that case, His Honour Judge Tolson, essentially took the lead in ensuring that all the questions that were put and the case management of the case was handled by him. And one could almost argue that in some ways that protected the father, because as a litigant in person, he wouldn't have been able to do that as well as an advocate, as well as the judge. And although he was disadvantaged by not being represented in his particular case, the judge dealing with the case in the way that he did was was to his benefit. But of course, judges also need to be careful about overstepping, as in the case that's listed there. I'm just mindful that of just making sure that I'm covering all that what's in the slides, but also the time. So if Zoe, I'm looking to you. If I'm running over, do please give me an indication that I need to move on.
Mindful, I think each of the other panelists need about 10 minutes each. So
yes,
if I could encourage you to limit yourself to a minute or two more.
Yes, of course.
Thank you.
Of course. Now, are the Scotch schedules the right approach? Now, I have to, as it were, highlight, we did attempt to influence the Court of Appeal in some way by suggesting that rather than calling the Scotch schedule a Scotch schedule, that we should have something akin to a heads of harm. Unfortunately, it wasn't taken up by the Court of Appeal. Quite disappointed when we read that our suggestion had not been taken up. But there certainly does see. Oh, I can see Miss Gilling QC is claiming heads of harm. You can have that, Miss Gilling QC. But essentially, it's accepted there does need to be a document. The Court of Appeal considered things like the similarity of the threshold document, pleadings. What's clear is that the Scotch schedule as it stands is probably not the right document. It's what we have at the moment, but it's not the right document. There does need to be, the Court of Appeal made it clear, statements of evidence that will allow the judge to look at the pattern of behaviour in a relationship over a period of time, particularly where there are allegations of coercive and controlling behaviour. And Miss Gilling, who's already claimed the heads of harm, point, we'll be talking a bit more about that. So I hope you have been able to follow me. I know I've gone quite quickly, and as I say, all these slides are available. So I'll pass over to Miss Gilling QC, who's chomping at the bit to talk to you more about Scotch schedules.
Thank you, Arlene. Thank you.
Welcome everyone, and thank you very much, and thank you, Arlene, and also taking some of my burden in terms of dealing with Scotch schedules. So I'm always welcome and happy for that. I'm going to hopefully keep it as short as possible in terms of the Scotch schedules, but looking at really in terms of the Court of Appeal and the parties themselves, they were critical of very much the restrictive nature of Scotch schedules. And of course, many of you will remember that Scotch schedules are brought in to really focus the allegations that parties were making, and for the response to be provided by the respondent, and for then the court to be able to have a very clear roadmap in terms of what findings were being sought. But unfortunately, what's clearly been developing and what has happened in the future was that a lot of these schedules have become extremely restrictive, to the point that it doesn't really meet the justice of the case. It doesn't really meet the allegations that are being put. So you'll see at paragraph 44, the Court of Appeal mentioned that there were two different really criticisms of Scotch schedules. One was one of principle and the other one more pragmatic. And in terms of the one of principle, that focused on the wider context of whether there has been a pattern of coercive and controlling behaviour, as opposed to a list of specific factual incidents. And really, in terms of coercive and controlling behaviour, you'll see later on in the judgment that the Court of Appeal went into more detail about that. And in particular, that sometimes, and the difficulty of Scotch schedules in restricting just dealing with factual aspects, it doesn't really give the proper complexion of the case and the allegations that are being made against the perpetrator or the alleged perpetrator. The second, which is at paragraph 45, which is a pragmatic aspect, which Arlene has touched upon, is the limitation that is usually placed on parties in terms of the allegations that are to be tried by the court. And it's quite understandable why this happens, because many times a very busy judge is faced with allegations, perhaps 30, 40 allegations in relation to a relationship that has been going on for a number of years. So it's understood that there has to be a marshalling of that information, and in terms of the court process, how it's going to be dealt with appropriately. But what has happened, it appears, and many a times, that the balance has tipped far to the extent that it's very much restricted to one or two allegations, which really does not give a proper and does not reflect what has been happening within the parties' relationship. And we all have to bear in mind what this is all about in terms of looking at any future harm to the children, and for the court to be armed with the information in order to make those decisions. And this is where very much the limitation of the Scott schedule has really fallen foul and perhaps not have been of assistance to the court as it could be. You'll see it paragraph 46, and that all the parties and all the appellants, and in fact the respondents, were really in agreement that Scott schedules haven't been perhaps as helpful as they could have been, and this was something that the Court of Appeal itself also agreed with. Melissa, if you could turn to the next slide, please. Now, dealing with the coercive controlling behaviour and the difficulty with the Scott schedule is that clearly just setting out specific facts or a pattern of acts is not going to meet the justice of the case. And what the Court of Appeal were very clear about is that there needed to be more detail. And when you're looking at coercive behaviour, you may be looking at really matters which are innocuous when you look at it on the face of it. But when you look at matters in a cumulative fashion, it gives a very different picture in terms of that parties and the parents' relationship. And in the circumstance, it was considered that Scott schedules were not particularly helpful in those circumstances. And you'll also see in terms of F&M, which the Court of Appeal referred to, which is the case of Mr. Justice Hayden, which helpfully set out and expanded in terms of the definition of coercive behaviour and really set it out in great detail for the parties to consider. And you'll see that at paragraph 4. And I would also invite you to consider paragraph 60 of that judgment as well. I'm not going to go through that, but what helpfully at paragraph 60 of that judgment, the learned judge did was to set out in detail examples of what could be seen to be coercive behaviour, such as depriving a parent of their basic needs, monitoring their time, taking control over certain aspects of their life. Now, when you look at those matters in isolation, it may be looked at in terms of a very much innocent explanation. But when you look at matters together, that would look at and consider to be coercive behaviour and controlling behaviour. So when it comes to considering what are the alternatives, the Court of Appeal, looking at the next slide, please. The Court of Appeal did not offer any guidance on this, and it considered, and you'll see that at paragraph 49, that this is a matter that should be considered by the private law working group together with the harm panel implementation group in terms of what guidance there should be and what issuing fresh guidance. Well, of course, many of you practitioners will be thinking, well, what do we do in the circumstances? When faced now with a situation whereby you have a client who is alleging coercive behaviour, what can we do in those? What can we do to put the best case forward for your particular client? Arlene has already alluded to and said that there were various arguments put forward, and you'll see that, such as from a threshold style schedule to heads of harm, which is something that we'd argued, that you set it out and then set out the head of harm and then to set out what facts you would rely upon there. But this is going to have to be something that is considered in the future. In the circumstances, that what I, and no doubt we would suggest is that, and I would echo very much what Arlene has said, is going back to practice direction 12J and going back and using that and setting out, first of all, when you look at the first hearing, to make sure that it's clear what the parties are going to be alleging. And for the court to set out whether it requires a Scott schedule or in fact requires some other form of document that deals with the allegations when you're setting out the coercive control. Now, in terms of paragraph 19 of 12J, what is of note is that the directions the court should give should be the key facts in dispute that needs to be set out. And also what the court has in its armoury is to say whether the key facts in dispute can be contained in a schedule or a table. So there is, in what I would suggest, at least some flexibility there, that the court doesn't always have to resort to a Scotch schedule if the court thinks it's far too restrictive. And what would be more of assistance, especially in cases where there's coercive control, perhaps there should be a short statement. And this is something that the Court of Appeal, when looking at coercive control in particular, and paragraph 58 of the judgment, sets out as the part of the process, the Court of Appeal offered a number of pointers. And one of those pointers, which is at 58B of the judgment, is that provide a factual basis for any welfare report of other assessments, provide a basis for an accurate assessment of risk. And importantly, looking at paragraph D, in every case where domestic abuse is alleged, both parents should be asked to describe in short terms, either in a written statement or orally at a preliminary hearing, the overall experience of being in a relationship with each other. So it's imperative, and I echo again what Arlene has said, which Arlene will no doubt like, is that it's important at the end of the day that these matters are dealt with very early on. The court is well aware of what facts it needs to find. And although there should be a move from this very much a restrictive way in terms of Scotch schedules, it doesn't mean then that the court is expected to litigate and hear about 45, 50 allegations, because fundamentally the facts that the court needs to find need to assist it in making decisions for the welfare of the children and what, if any, potential harm there is for the child. Now, other matters would be to consider the application form and making it clear on the application form if there's going to be an allegation of coercive control. Also, for the application form to be very clear if special measures may be required at some stage. For the allegations to be recorded in whatever format the court considers appropriate and the court considers to be most helpful. And in terms of taking instructions from clients, looking at the types of coercive control there are, and making sure that those are all covered in the initial instructions that you are taking, so that you can put that in your application form and ultimately be able to put that in the document that you will be inviting the court to make decisions about. It's important that any document setting out allegations will need to be clear about what is alleged, because the alleged perpetrator will need to be able to respond to that. And no doubt most of you, if not all of you, be mindful that many, if it's alleged perpetrator, is unlikely to have legal representation. So it's imperative that that is clear for them to be able to respond in those circumstances. And finally, and I hope I've probably overshot my time as well, but finally, can I, what would be of help is to hear others at the end of this comments in terms of your observations about dealing with Scotch schedules, any views that you have, and any suggestions about how this could be improved. So I'd probably race through that as well, but hopefully that's been of some help. Thank you.
Thank you, Denise.
Thank you. The next issue that the Court of Appeal dealt with was in relation to the use of criminal law concepts and principles, whether we should use those and to what extent. Very helpfully, the Court of Appeal set out for us the key authorities in relation to this, paragraphs 60 to 74 in their judgment. I'll try and race through these as quickly as I can. So the key one is RE-R. This is the 2018 Court of Appeal decision, which was ultimately reaffirmed by the Court of Appeal in RE-HN. And briefly, the trial judge in that particular appeal had made a finding that the father had used unreasonable force and had unlawfully killed the mother. and the father had not been acting in self-defence. And the trial judge in that case, I think was Mr. Justice Tice, referred to the criminal law, particularly relating to self-defence, and she'd given herself a detailed direction about that. And so on the appeal, one particular point of appeal was whether it had been correct for her to rely so heavily on criminal law principles, and particularly the law in relation to self-defence. Another issue was that she hadn't properly considered the other defence of the loss of self-control. The key paragraphs are set out within my slides, and you'll be pleased to know I will not be reading those out to you. But in summary, the court found that, of course, the criminal and the family jurisdictions have completely different aims and purposes. The former deals with culpability and punishment. The latter is dealing with the best interest of a child and will only make findings in order to determine arrangements for a child. In terms of criminal law concepts and elements, the Court of Appeal made it clear that those should not be imported into family law. We are not looking at the specific elements that need to be proved or established in order to constitute a criminal offence or those particular defences. The Court of Appeal also said that language such as murder, loss of control, self-defence shouldn't ordinarily be used in relation to findings made by a trial judge. The reasons they gave for those were multiple different reasons, but the first one was, quote unquote, the potential for the process to become unnecessarily bogged down in legal technicality, and that in reality, if this were to be the case, that family judges would need to be dual qualified in both the criminal and the family jurisdictions, which wasn't a practical option. Then the next authority was the case of F&M. This was a decision of Mr. Justice Cobb, in which he applied the case of Re R. In this particular case, the trial judge had made a finding within private children proceedings that the father had raped the mother and the child had been conceived as a result of that. He'd gone on to make more detailed findings than that. But that in essence was the finding they made, and the key was using the terminology of raped. That formed one of the grounds of appeal. Mr. Justice Cobb again made it clear that the family courts should not be occupied in trying to prove a particular ingredients of criminal offences or defences. But he did say that actually it was permissible for the trial judge to use the concept of rape within the findings that the trial judge had made. And that clearly was relevant to the future planning for this child. A potential spanner in the works was thrown in by Miss Justice Russell in a case I'm sure you all know, which is JH and MF, in which she considered an earlier decision by His Honour Judge Toulson in relation to a fact-finding hearing concerning rape allegations. In this particular, and the reason this came before the Court of Appeal was that some parties had said that there is a potential inconsistency between the approach that she took and the approach that was taken by the Court of Appeal in RIAR. And the reason that they said that is because she'd relied quite heavily on the criminal law. She'd, for instance, referred to the Sexual Offences Act 2003. She'd referred to the criminal law on consent, as well as to numerous criminal law textbooks like Archbold and Blackstone's that I have dim and distant memories of. And what she had said is, while a trial in the family court cannot and must not set out to replicate a trial or to apply or to seek to apply criminal law or statutes, it cannot be lawful or jurisprudentially apposite for the family law, for the family court to apply wholly different concepts or to take an approach wholly at odds from that which applies in the criminal jurisdiction. So taking that all into account, what did the Court of Appeal make of it and what guidance did it give us? As I said earlier, they reaffirmed the decision of RIAR, which was in 2018. They said that was the correct approach to take. They also said that insofar as JH and MF departed from this, that as far as the Russell J case departed from it, the case of Re R took precedence and was the valid case to apply. They said, in essence, a court needs to determine how the parties behaved rather than determining whether that behaviour is capable of falling within a particular criminal offence. And then, of course, behaviour which may well fall short of a criminal offence may well still be relevant to the aims and the purposes of the family court. For instance, the Court of Appeal gave an example of saying, well, if one parent causes a physical injury to another one, it doesn't matter whether it's classified within the criminal law as ABH or GBH, it's the fact of the injury which matters. The Court of Appeal did recognise, though, that some particular criminal concepts are used in everyday ordinary language. That included the use of the word rape, and so they said that trial judges can use that terminology within their findings, and that in and of itself would not make those findings unsound. In terms of direct application of the criminal law, again, the Court of Appeal said that is not the correct approach to be taking. The family courts should not be doing that. They interestingly, at the end of this particular part of their judgment, flagged up some potential future issues that they weren't going to deal with, but hopefully will be dealt with at some point in the future. Those mainly related to procedural issues. So, for example, whether there should be cross-examination of an alleged victim of sexual abuse on their previous sexual history. Of course, the criminal jurisdiction deals with that very well, and we have limited rules in respect of it, but that will need to be dealt with in the future.
Thank you, Melissa. I think that then makes me the final speaker for today's lineup. You'll all be thrilled to hear. And my role is to look beyond the judgment and give you all a bit of a whistle-stop tour of the ongoing efforts to address how the family court deals with domestic abuse. There were two quotes within the judgment that I actually found really helpful, that helps us to think about ultimately how challenging and difficult it is to review the approach to domestic abuse by the family court. The quotes are in front of you. The first, that the family court is engaged in a continuing process aimed at developing and improving its procedures. I mean, it's pretty trite, but it's an important statement to remember. There is no golden bullet. What we do need is time and buy-in. And then to add to that task is the wider context of the complexity of domestic abuse, in that the task of reviewing the approach to domestic abuse, the court said rightly, is a complicated one, in respect of which the understanding of society, those who work with victims and politicians and professionals, is developing all the time. So not only do we not have a golden bullet, we have a very movable feast with an awful lot of players who are required to improve the system. And what you will know from what the Court of Appeal does say is a lot of this isn't for us. And who is it for then? What I'm going to touch upon is the harm report, the domestic abuse bill, which is hopefully soon to be implemented, the efforts of the private law working group, and then finally, just a bit of a note from me about what we can do as practitioners and professionals before those things come in, and what's already happening now. Next slide, please, Melissa. Thank you very much. So the harm report, you'll excuse me, I'm going to assume a kind of lack of knowledge in the virtual room and just give some basics. So my apologies if some of you are aware of this already. The harm report is the short name for the far longer name of a report released last year in June 2020. The longer name, Assessing Risk of Harm to Children and Parents in Private Law Children Cases, ultimately assessing the risk of domestic abuse in private law children cases. Now, the harm report is 214 pages long. So you will be forgiven within all our very busy daily schedules if you have not managed to read the harm report in full. What I will say for the harm report, it has a very excellent executive summary, which lasts only 12 pages. And I have to absolutely commend you to read it. If you read nothing else, the first 12 pages really are a very helpful read. And what they do is they present the challenges that the family court presently faces, and they also helpfully look at the remedy. Now, I haven't set out for you those 14 recommendations. I wanted to say two things. The first is just an awareness about the status of the harm report. So the harm report is a document that is recommendations only. The government has separately provided an implementation plan, but not all of what is in the report is also in the implementation plan. However, in good news, some of it is actually already being implemented. Now, I picked out 5 that I think are most pertinent, and I'm actually going to reduce those even further to 3 of those 5. I'm going to touch quickly on reform of the child arrangements programme. So that's one of the things that the harm report recommends. And the reason I touch upon it now is to say that it is already happening. And one way that it is already happening is earlier involvement of CAFCA along the lines of what Arlene already talked about. I don't know about others, but I received an order from Peterborough Family Court a couple of weeks ago that told me that there is a first hearing, but none of the parties were invited to attend, and only CAFCA and the judge would attend and would decide the way forward, in the hope that they can flag up early cases where there needs to be timetabling and more time given to addressing any harm or safeguarding concerns. So looking to address what Denise and Arlene have touched upon about dealing with these cases early. The other point that I want to touch on is with regards to resourcing. Sorry, Melissa, you've took me one on slightly too quickly. Thank you. The other one is resourcing. I think whenever we read these reports, we're among friends, we slightly roll our eyes and think, but what about the resources? And helpfully, the harm report does acknowledge the need for greater resources. And particularly, and I'm going to come to it at the end of my slot, is it also says legal aid should return for both applicants and respondents. And I think that is a really important drum that we need to bang, that potentially we've all gone a bit quiet about, but that the harm report now once more raises for us. The last thing I'm just going to mention about the harm report is training. Within the judgment, the judges did comment on judicial training, but rightly the harm report looks at training for all of us within the family justice system, and that very much follows through to the domestic abuse bill, which then leads me nicely onto the domestic abuse bill. It has been trundling along for some time. I'm told that it had its last hearing in the Commons on Tuesday. The next stage, fingers crossed, is royal assent. What will the bill provide then? It provides for an awful lot. I'm going to comment just on 2 aspects. One is education and training, same thread as what we heard in the harm report. But actually, and interestingly, the education and training proposed as part of the domestic abuse bill is far wider than the harm report. It looks at training in schools, so guidance about positive relationships for young people. It looks at training for the police. It looks at training for social workers about coercive and controlling behaviour. It looks at training for frontline probation officers, and it even looks at training for specialist services in job centres. So fingers crossed, when the resources are provided to provide that education and training, we will see some of that important cultural and societal shift that some of the women's groups have rightly been calling out for a number of years. The other headline provision that I think is important, that many practitioners will already be aware of, is that alleged perpetrators will be prevented from cross-examining in certain circumstances. Now, it isn't an outright bar. It's still only certain circumstances. And if those certain circumstances are met, such that the judge considers it would cause distress and or impact the quality of the witness, or there is a criminal offence, which already means that, in short, you could apply a bar, what will be replaced is the provision of some form of funding and a qualified legal representative. So in one sense, hallelujah, this has at last come in, but it isn't that absolute bar that many were looking for. Now, the final question that I pose within this slide is, will the Domestic Abuse Bill solve the issues raised by women's groups and the Court of Appeal in this judgment? The one thing I would flag is that rightly lots of our discussions have actually been about the advice and the process pre-fact find. What the Domestic Abuse Bill does is it only provides legal representation at the fact find hearing. So that lacuna that Arlene was talking about is still very much there. So I'm sure for many the hope is that what the harm report will do is get greater impetus within the working group that I will come on to just briefly mention, and to address once more the legal representation. That brings me on then, and I'm talking quickly, to the private law working group. I'm going to say very little. It's headed up by Mr. Justice Cobb. It's been in train for a number of years and it's now on its second report, and it's made a number of recommendations across the breadth of private law. So it's not just about domestic abuse, about how to improve the system along the lines of enhanced parenting education and, for example, child arrangement programs which have different tracks. The one thing that I would say that I really like about the report is the quote that is on your screen. Because if we know we are low on resources and we need more resources, we also know we need impetus for change. And I think this quote in front of you really gives us, hopefully, that impetus for change. My last point then to make is, what can we do now? What are we seeing that's happening now that goes beyond what the Court of Appeal has said that can improve the system? There was talk within the judgment about what's known as the Watford model. Excuse me, it wasn't within the judgment, it was within the hearing. We call it the triage system in Leeds, and it is the approach that CAFCA are involved earlier to address those cases that do need their early input. There is also talk about the Integrated Domestic Abuse Court coming in hopefully by the autumn, which would be great progress, and this would of course centralise expertise and knowledge. From the point of view of training education, it plays a big part in the harm report and the Domestic Abuse Bill. I wanted to introduce you all to something that I found hugely helpful. It is a theatre performance called Rattlesnake. It's a situation in where two actors perform the lived experience of two women who suffer the abuse of coercive and controlling behaviour, but from the same man. I cannot tell you how helpful I found it to understand what coercive and controlling behaviour looks like. I actually watched it with a group of North Yorkshire police officers, and it was very interesting to hear them say afterwards that they had on reflection realised that perhaps they had missed incidents of coercive and controlling behaviour having watched that. My last point then, and it goes back to what Denise talked about with regards to Scott schedules, is there will obviously be a need for a change of mindset. I read an article a couple of weeks ago which described it as understanding the nature of relationships over and through time rather than articulated at one point in time. And I really liked that description, because I do think that coercive and controlling behaviour is some of the most insidious behaviour, but it is the hardest for a victim or an alleged victim to articulate. So the more we can do to get our heads around about how we assist our clients with their narrative and the journey, the better. The last thing I'm going to finish on is actually how Arlene started. I'm going to make a confession. My confession is that I'm a pathological optimist. I read the working group report, and when I read this sentence, I will be direct. We are direct to the north. The sentence reads, the legal aid reforms of 2012 have been counterproductive to the effective resolution of private law disputes. And when I read this, I thought, no S. Sherlock. That's not a surprise to any practitioner who's been in the system for the last 9 years. But what I will say again is that the harm report does recommend the return of legal aid for both applicants and respondents. The working group recognises how counterproductive its absence has been. The domestic abuse bill will not deal with the issues that will need to be dealt with prior to a fact-find hearing if parties are unrepresented. So I know we all get into our situation where we think, well, it's not changed for 9 years, so why would it change now? But I do hope once more that there will be an impetus so that actually if parties are represented, it will free up the court system far more and prevent the awful delay which we all know we are experiencing. That is my plea and call, and returns to Zoe. My apologies, Zoe, 5 minutes over time.
Thank you, Claudia, and thank you to all the panelists. We are 5 minutes over time. I can still see that we've got a high number of participants, so you're welcome to stay on. I'm going to keep this open for another 10 minutes. We have, so bring your comments and questions coming in. We've got a question, a very interesting first question, which I would like Arlene to deal with. Just a reminder, this judgment was handed down on the 30th of March, and one participant has asked, well, what about those case management decisions taken before the 30th of March? Perhaps those that have said, well, you will limit your allegations to 5 or 6 allegations. Arlene, may I ask you to deal with that question, please?
Yes, of course, Zoe. I would say go armed with a copy of this judgment and take the relevant judge, whoever he or she may be, take them to particularly paragraph 51 of this judgment, which deals with the overarching issue which should be tried first, which is that of coercive and controlling behaviour. So looking at the wide range of the relationship, not individual incidences in isolation, and also the paragraphs that Denise was talking about, and that's in relation to paragraph 58 and 59 of the judgment, which makes it clear that there will need to be proper consideration of practice direction 12J, and also looking at the need for statements. It's not good enough that we're going to carry on doing things as usual as if this judgment does not exist. And I, in fact, just this week received an order where, in fact, a litigant in person pushed back against a judge who told her that she could only have 5 allegations, and she said that will not do my case justice. I want permission to file more. And it was recorded as a recital that she has permission to file more, and then the trial judge will assess them at the hearing itself. Now, I'm not saying that that's an ideal way of dealing with it, but what the point I am making is that early case management is all of our responsibility. And if there is a particular judge who is not understanding the importance of making sure that these matters come before the court in the proper fashion, as I say, have a copy of the judgment electronically or in paper form if you prefer paper, and make sure that you're taking the judge to it. It's not to, provided the fact-finding hearing has not started or even at the door of the court, it's important that judges are aware that we must take this judgment seriously.
I suppose in whatever way you can, alert the court as soon as possible that you're not going to be able to comply with the direction. That is our duty, isn't it, as officers of the court,
Yes.
to say to the court, okay, you've given us this direction, but we're not going to be able to comply with it because it's limiting. There's coercive control. That's not going to bring about justice. I've got some more questions coming in. Yeah, I mean, we're getting more comments and shared experience, which is really helpful. That, you know, we've got delay in private law proceedings. You know, we're waiting for a trial. It is a struggle, isn't it, with case management, knowing that if you're going to ask for more days, there's more delay. I don't know if anyone else wanted to jump in on that. But if you're going to do your clients,
I know I've spoken already. I'm just sort of again dealing with that point I've seen about that there's already been delay, but it's got to be seen in the context of if it ends up in the Court of Appeal. One of the things that we are tasked to do as advocates is bring these matters to the attention of the trial judge however late that may be. So even though there has been delay, I would still say it's important to flag it, because it may even become a point of appeal later on down the line if the outcome of the fact finding is not as it should be. If I'll just say that, if it's not the right outcome, then you end up in the Court of Appeal. At least you can say that you raised these issues with the judge, with the trial judge, as soon as they became an issue.
Thank you. We've got another interesting question about the tension between interim supervised contact proceeding and there being a fact find, and then the tension between having supervised going ahead and whether there still needs to be a fact find. I don't know if anyone wanted to come in on that one. It's true, quite often a judge will think, well, we've got contact going ahead, why do we need a fact find if there's already contact? And I think this is the problem with the binary nature of allegations. Either an allegation is found proven and therefore those findings are relevant to decisions on welfare and contact, or if it's not found proven, then contact is going to proceed. So in one of the questions that we've had, I'm not sure what this judgment is. There's been reference to a judgment in a case on Monday. Where there was agreed interim supervised contact rather than a 2-day fact find, and this case was referred to in deciding not to proceed with fact find. I mean, that does sound quite a complex situation, because clearly if the allegations are relevant to whether unsupervised contact can go ahead, then that's a clear reason for there being a need for a fact finding. And this is how we have difficulties, quite often solicitors managing their clients' expectations, because clients won't want a stressful and expensive fact finding. And then you have to say, well, if there aren't any allegations found proven, the judge will work towards unsupervised contact. You know, that's the binary nature of our process. Okay. I'm conscious of the time. Did anyone want to share any closing comments? I think the panel has dealt with a huge range, and we've got the handout to share. So I think I'd like to conclude just by saying thank you very much to our panel for their time and thoughts across the range of developing law on the issue of coercive control and fact finding. I'm going to close the meeting now. Thank you very much, everyone, for attending, and have a good evening.